This is Left Voices for Thursday, June 12th, 2014. I'm Andrea Sears. Tonight,
this particular case for the three guys that we have out of our six who continue to be held and abused long after they were found to be not enemy combatants, I think was in a lot of ways pretty unique and maybe the last guest for these kind of claims in federal courts.
Former Guantanamo detainees are once again denied their day in court. A federal appeals court has dismissed a civil lawsuit brought by 6 men formerly held at Guantanamo who were wrongly detained and abused long after they had been found not to be enemy combatants. The suit, one of the last remaining Guantanamo damages suits, was brought against former Defense Secretary Donald Rumsfeld and other military officials for the torture, religious abuse, and other mistreatment of the plaintiffs. 3 of the plaintiffs had been cleared for release by Combatant Status Review Tribunals, or CSRTs, and yet extreme abuse continued until they were finally released, in one case almost 2 years later. The other 3 had been released before the review tribunals were put into operation. In dismissing their claims, the court said that the torture and religious humiliation these men endured, even after being cleared for release by the military, were a consequence of the military's need to maintain an orderly detention environment and appeared to be standard for all military detainees in Guantanamo, Iraq, and Afghanistan. Shayana Kadidal is the managing attorney of the Guantanamo Project at the Center for Constitutional Rights.
These guys were subject to sleep deprivation, other forms of torture, prevented from praying, forcibly shaved their beards, being medicated against their will, and so forth, all after they were cleared. And yet the court said that they can't seek damages in federal courts against the individuals responsible for that, including folks going all the way up to the Pentagon, because essentially torture and religious humiliation are par for the course for detainees in the custody of our military, that they're foreseeable and that this is kind of standard practice, and therefore the right entity to go after is the United States, which has sovereign immunity, rather than the individuals who carried out these abuses and directed them. And if the court is correct that torture and religious humiliation are basically standard practice for detainees in the custody of our military, I think that's just a tremendous indictment of the way the United States treats its detainees everywhere in the world. Sadly, pretty much every court to have dealt with these issues has come to roughly the same conclusion.
Specifically, the judge said it was foreseeable because maintaining peace, security, and safety at a place like Guantanamo Bay is a stern and difficult business.
In any prison, there are compliance issues, and then there's typically standard punishments. Sometimes people are put in solitary briefly for a day or two in American prisons for violating the rules. But that doesn't reach the kind of things that happened here, where people were held in solitary for long periods of time, where folks had their beards forcibly shaved, where they were prevented from praying. You never see that in American prisons. Things were done to them that were against even the military's own psychologists' advice based on particular kind of debilitating conditions that certain of our clients were suffering from. And all of this happened after these guys were found to be not enemy combatants, as close as the military ever comes to acknowledging they made a mistake in picking these guys up in the first place. And yet they were treated just like the presumptive worst of the worst were when the military was trying to interrogate people to get information out of them by somebody's primitive idea of breaking people.
The court also said that the abuse of the prisoners was a direct outgrowth of the defendant's instructions or job assignment.
The idea here is that ordinarily there's a lot of discussion in any kind of tort case about whether or not an employer ought to be liable or the individual employees. Now, when you're suing federal government officers, as a lawyer, you've typically got to sue the individuals because the government itself enjoys sovereign immunity, and it's very, very hard in court to get around that. So it's a par for the course that we civil rights lawyers will always direct the lawsuits at the individuals. But there's this doctrine called scope of employment where in the federal system, the federal government can come in and substitute itself for the individual officers if it's found that the individual's actions were within the scope of employment, meaning, something that the master, the employer, the United States, could have foreseen that they would do. So here what the court is saying is, the United States could have foreseen that the Defense Secretary and everyone on down below him would have engaged in torture and religious abuse as part of our program of military detention, even for people who were cleared. So this is sort of taking this doctrine of scope of employment to ridiculous extremes. It's one thing if a furniture company hires a furniture delivery man and that man turns out to sexually assault the person he's delivering something to. That is something where a court might reasonably say, well, that's within the scope of employment. One might expect that if you weren't careful about who you hired, they might assault people and you, the employer, should be liable for that. Here, the federal government is coming in and saying, hey, we, the federal government, are actually the one who's responsible because these underlings from Donald Rumsfeld on down of the United States could have been expected by us to abuse the hell out of prisoners at Guantanamo, even after they were found to be not enemy combatants. And therefore, the United States is the one you should sue. And oh, by the way, the United States has sovereign immunity. So, case over.
The courts have generally been reluctant to rule on cases involving the conditions of confinement or abuse of the prisoners at Guantanamo. The most recent exception was a brief ruling enjoining the government from force-feeding one of the detainees. Have there been any successful challenges to treatment or conditions of confinement?
Well, we're still waiting to see how that whole process comes out. In habeas cases where someone is still in detention, at least to me, I think it's pretty clear that if the conditions are so bad that they interfere with the detainee's right to participate in his case, if they make the person so psychologically disabled, so physically disabled that they can't meet with their lawyers, provide evidence, and so forth, then if the court has habeas jurisdiction, they obviously have to have jurisdiction to step in and remedy that kind of thing. So these damages cases are a little bit of a different bag in that they're post hoc. These are all cases brought for damages only by people who are already released. They're out of the control of the U.S. government. But the cases where people are actually still in detention, I think those present a much more difficult challenge for the government to try to weasel out of actually being responsive to a court.
So is there any recourse left for detainees who have been released who were subject to this kind of treatment?
Well, I think this is really one of the last categories of lawsuits out there. There are certainly people who are filing and fighting cases, but their cases are, I think, fundamentally very similar to a lot of cases that have been litigated in the past. In the last year, there's been litigation by a guy who won his habeas case who said, a court decided I was wrongly held from the beginning. I was not an enemy combatant, and therefore my case is different from all the other ones you dismissed, and his claims were rejected. Similarly, there was someone who was cleared by another type of military panel, an annual review board, administrative review board, or ARB as we call them, and his claims were rejected as well on a bunch of different, very technical legal immunity doctrines. Basically, the Ninth Circuit said that the Military Commissions Act was designed to throw his claims out of court from the get-go. And that's actually a case that's pending before the Supreme Court to see whether the court will review it or not. But this particular case for the 3 guys that we have out of our 6 who continue to be held and abused long after they were found to be not enemy combatants, I think was in a lot of ways pretty unique and maybe the last gasp for these kind of claims in federal courts.
And the Supreme Court has so far been unwilling to take these cases up.
Yeah, dead silent. The leading case was called Rasul v. Rumsfeld for a number of English detainees, including Rasul himself, whose name was on the first Supreme Court case extending habeas and the right to a lawyer out to Guantanamo. That case went up to the Supreme Court at the same time as a second habeas case, Boumediene, and the court at that point reversed what the D.C. Circuit had done with the case, this whole scope of employment thing that we've talked about, and said, take another look in light of our recent decision saying that there's a constitutional right to habeas at Guantanamo. And the D.C. Circuit said, we've taken another look and we make exactly the same decision, and then the Supreme Court declined to review the case. It doesn't mean the Supreme Court thought that decision was correct. It just means that for whatever reason it wasn't one of the 70 most important cases of the year for the court's attention. So you may very well try to petition the whole D.C. Circuit or the Supreme Court itself to review the decision that we just got this week. But the court has already had one shot at the big question in that case and decided for whatever reason back in 2010 that it didn't want to hear that case.
So about the only recourse left would either be an international body which might rule, but the United States would be likely to ignore an adverse ruling, or a legislative remedy recognizing that harm was done.
Right, maybe on the lines of the Japanese-American internment compensation decades after the fact. You know, at some level, maybe that's the most likely thing to happen here, but I wouldn't hold my breath even for that in our lifetimes.
Shayana Kadidal is the managing attorney of the Guantanamo Project at the Center for Constitutional Rights. This has been Left Voices for Thursday, June 12, 2014. Join us again next time for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.